court's inclination to not impose any sentence of incarceration, a sentence authorized by the conviction, but one the people no longer view as a practicable recommendation. Graham, I want to ask you, did this come as a surprise to you, considering that there were a couple of other options on the table from DA Alvin Bragg, including treating this case like they would with someone who is deceased in terms of having the conviction stay but not imposing a sentence, or waiting for sentencing until after the completion of the next term? Does it surprise you in this world that you're steeped in that we will now see a sentencing barring any other events on January 10th?
Surprise might be the wrong word. I think that their motion, their prosecutor's motion, acknowledged that jail was increasingly a hard outcome to picture because of Trump's election. The suggestion that it be put off for 4 years until after his presidency was one that would maybe only be worthwhile if jail were in the cards. But he can't appeal his conviction until after sentencing. So this is kind of a good middle ground where he's able to continue to pursue his rights as a defendant while he's president. But the whole country isn't left waiting for 4 years to find out what's going to happen with this case. And he as a defendant doesn't have to wait that long either. He now knows that on Friday he's set to be sentenced, not going to be sentenced to jail time, and that's off the table. And he can move forward with his life, and the case, at least the part of it that involves this local court in New York City, can move on.
Graham, I'm going to throw you a curveball before I let you go. And the man on the right side of the screen, this is Todd Blanche. This is Trump's attorney in several other criminal cases, including this one, the falsification of business records related to payments made to Stormy Daniels, which Trump denies. Todd Blanche, he's been picked for Trump's deputy attorney general. So again, this is a curveball, and I don't know if we know the answer yet. But is it likely that his legal team will take new shape, given that he has nominated Blanche to that position?
Yeah, at some point it will have to. Right now, Todd Blanche is his personal attorney, and Al Lode is also going to the Justice Department from Trump's New York defense team. So in order for them to be, the Department of Justice doesn't argue in local New York courts, and not for private criminal defendants. If the question is, will the Justice Department at some point get involved? If after New York's whole court system, all the way up to its highest court, which is called the Court of Appeals, works its way through this case, and they move on to appealing it to the Supreme Court, for instance, that might be a different matter for the Justice Department. But the Justice Department is not typically involved in state criminal matters. So it's reasonable to expect that there will be some new faces involved after Trump becomes president for his local criminal defense.
Graham Cates, thank you so very much. Let's go to CBS News reporter and lawyer, attorney at law, Katrina Kaufman. Katrina, good to see you again. I understand that you have an excerpt of the motion that you would like to dive into a little bit. Go ahead and tell us what you've identified as a significant part and why.
Yeah, so on page 7, Lindsay, there's an interesting passage where Judge Merchan points out that Trump is now saying that there's too much of an undue burden on him to be sentenced before he goes into office during this period between the election and his inauguration. But what Judge Merchan says is that this is actually what Trump asked for. He said that he wanted the sentencing, which, as we discussed earlier, was originally set for September, to be moved to after the election so that it would potentially influence the election results. So Merchan writes, while defendant now claims this court cannot and must not sentence defendant, the record is clear that defendant not only consented to, but in fact requested the very adjournment that led us down the path that we are on. And he says any claim defendant may have that circumstances have changed as a result of his victory in the presidential election, while convenient, is disingenuous, says Merchan. So he really points out very clearly here that Trump asked for the adjournment, and that clearly if he was elected, which He also says that Trump was always very confident that he would be elected into office, that he had to know that the sentencing would need to take place during this period. Also, as you were just talking about with Graham, I mean, he also points out that really to serve all interests and bring some finality to this, he needs to do the sentencing before Trump's inauguration. And again, he says that Trump has always made it clear that he wants to use every appeal that is available to him. And he really can't do that until after the sentencing. He cannot appeal this conviction.
So what could happen given that it sounds like jail time's not on the table?
So as you were discussing earlier, what the judge is saying is it looks like he's leaning towards what's called unconditional discharge. And under New York law, that means that Trump would remain a convicted felon, but he would be released without any term. So there would be no imprisonment, there would be no probation, there would be no fine. So it's looking like, according to this, that's what the judge is leaning towards now. He is making it clear that he is not going to serve Trump with jail time. But another thing that I don't think we've talked about yet that could be interesting at the sentencing, if Trump decides to do so, is that a criminal defendant is allowed what's called allocation. They can speak on their own behalf at the sentencing for a criminal trial. So often this is the moment where a defendant might choose to express remorse, to explain what happened, provide details that maybe aren't in the probation report. And as we may recall, Trump decided not to testify during the trial. So it is possible that this could be a moment where we hear Trump himself speak about this case if he chooses to do so.
Katrina Coppin, thank you as always for your analysis. Let's bring in CBS News legal contributor and Loyola Law School professor Jessica Levinson. And Jessica, I want to ask you, I kind of want to hone in on one thing that Katrina had said, and that is that if there is a sentencing, I believe she said conditional, where under New York law, the conviction would stay, he would be a convicted felon. What, if any, effect would that have on Trump's day-to-day life if he is walking through life holding on to that felony conviction?
I think very little. So let's be clear that under the Constitution, any person who is convicted of a felony can still be the president of the United States. Small caveat here, there's of course that continuing question under Section 3 of the 14th Amendment as to whether or not related to separate actions, specifically January 6th, the president is barred from being president again. But Lindsay, to your excellent question, it's unconditional sentence. It's a conditional sentence. It's a fine. I think anything short of you will be incarcerated for some period of time after January 20th, which we knew wasn't going to happen, anything short of that really will not be an impediment to President Trump's ability to function as president.
I mean, would he be able to, for example, vote in the midterms? I mean, some states have restrictions, but others say after you completed your sentence, you can vote. And if there's no sentence,
I'm going to go based on memory here, which I believe is always dangerous to do on live television. But
Amen.
We're talking about somebody who is registered to vote in Florida. And the question as to whether or not a convicted felon, because there's no question about the conviction and whether or not it will stand. It will stand. And what I believe is that last time this question came up, the answer is that Florida refers to the law where the person was convicted. And under New York law, based on these felony convictions, you could still vote. And so Florida is going to refer back to New York. New York's going to say you can vote. And so Trump in Florida could vote. So I think that's the answer to that question. But it reminds us that we've never been here before. We've never been in a situation where the president is a convicted felon, and we're having conversations like, what if he was on probation? What if he had, which he won't, let's be clear, based on this particular memorandum from the judge, what if he had an ankle bracelet? Like, what if? I think the answer for everyone tonight is, One, that the conviction, according to this judge, should stand, that there was plenty of evidence to support it, that nothing the Supreme Court said and nothing about the election will change that, and that there will be no jail time and, frankly, no significant punishment. That the punishment, which frankly may not be particularly impactful for President Trump, is that he will forever be known as a convicted felon.
Jessica Levinson, thank you so much as always. And while we've been talking, we did just minutes ago get a response from Communications Director Stephen Chung on behalf of Trump saying, quote, today's order by the deeply conflicted acting Justice Merchan in the Manhattan DA witch hunt is a direct violation of the Supreme Court's immunity decision and other long-standing jurisprudence. This lawless case should have never been brought, and the Constitution demands that it be immediately dismissed. President Trump must be allowed to continue the presidential transition process and to execute the vital duties of the presidency unobstructed by the remains of this or any remnants of the witch hunts. There should be no sentencing, and President Trump will continue fighting against these hoaxes until they are all dead. Just one note, because they did mention the immunity decision, and as we've been discussing, the judge did mention in his motion that he did not find any of Trump's legal arguments to be compelling, a compelling reason why the immunity decision would have applied in this case. He said that these acts were unofficial acts and therefore not protected by